All right, good morning. This is People versus Alex Larson. That's file 192499FY. And Mr. Connolly is here on behalf of Mr. Larson. And Ms. Danichuk is here from our probation office. This is the date for both a show cause hearing as well as a probation violation hearing. And let's see, actually it says arraignment. So Mr. Connolly, with regard to the probation violation arraignment, first of all, have you discussed the defendant's rights with him?
Yes, Your Honor. So we actually had the arraignment yesterday on the probation violation.
Oh, you did? Okay. So what does your client wish to do about the probation violation?
Your Honor, he was going to admit responsibility for the violation. He does have a reason for missing one of the dates, but he will admit to the rest of the violations.
Okay. And with the show cause hearing, let's see, what does he wish to do with that?
Your Honor, he admits he did not turn himself into the jail, but he does have a reason he was hospitalized on that date. So he can explain why he was unable to turn himself in on that. But he will admit that he did not turn himself in as ordered on time.
Okay. All righty. So, Mr. Larson, I need to go over your rights with you before I accept a plea to a probation violation. I want to make sure you understand that you do have the right to contest this and to have a hearing, and Mr. Connolly would represent you in that, and you'll be giving up that right if you do plead guilty. Do you understand all that? Mr. Larson? You're muted. So if you could please unmute yourself.
Are you talking to me, Your Honor?
No, I'm talking to Mr. Larson, although I did click your unmute button by mistake. Mr. Larson, can you hear me?
Yes, I can hear you. My phone cut out. I'm sorry. I had to hang up and call the phone number back.
Okay, so did you hear what was being said up to this point?
A little bit of it. Like just the beginning of it.
Just the beginning. Okay, let me start again then. Mr. Connolly indicated that you are going to admit to the failing to turn yourself in on the show cause, but also admit to the violations of probation in the report. And I want to make sure you understand you do have a right to a hearing and to be represented by Mr. Connolly in that hearing, and you'll be giving up that right to a hearing if you plead guilty. Do you understand that?
Yes, I do.
And do you also understand the worst that could happen? It's not being recommended, but your probation could be revoked and you could get up to a year in jail. And you understand that as well.
Your Honor, I was told 45 days.
Okay, well, let me talk about that. The recommendation is for 45 days in jail. I generally follow the recommendations of the probation office, but I don't always. And so you should be aware that that the worst that could happen is you could get the year. That's what I'm required to advise you of. Do you understand that?
Oh, okay. Yes.
Okay, and do you wish to go ahead and admit to the violations?
Yes, I do. And did Mr. Connolly go over why I missed my turn date?
That's what we're going to.
He just mentioned it, but he did not go into detail. So you'll get an opportunity to do that as well, okay?
Okay. All right. Thank you, Your Honor.
All right. So I need to ask you some questions to establish there was a violation of probation. So it says here you were placed on probation June 10th of 2020 for malicious destruction of property, 200 to 1,000. And as a condition of that, you were required to submit to drug and alcohol testing. Do you is that true?
Yes, Your Honor.
And you were also required to engage in counseling. Is that also true?
Yes, Your Honor.
Okay, and the report says that you failed to do drug screens on May 29th and preliminary breath tests on May 25th through the 26th and May 29th through June 4th. Is that true?
Yes, Your Honor. And June 4th, I was in the hospital for my injury.
Okay.
Well, I wasn't in the hospital, but I just got out of the hospital and I couldn't go anywhere. So.
Okay. I will give you an opportunity to explain whatever you want before I decide what to do about this. But for right now, I just need to establish the violations.
Okay.
So did you also not attend your counseling as you were ordered to do?
Yes, Your Honor.
Okay. To those violations, how do you plead?
Guilty.
All right. And you also admit, as far as the show cause hearing, you failed to turn yourself into the jail when you were supposed to. Is that correct?
Yes, Your Honor.
Okay. All right. So, Mr. Connolly, what would you like to say on behalf of Mr. Larson before I sentence?
Thank you, Your Honor. Mr. Larson indicated to me, Your Honor, that about the beginning of June, he was in an accident on the work site building pole barns. Apparently, one of the walls collapsed and struck him in the face, and he had to be taken to the hospital and have surgery. We had to have titanium plates put in his face to fix shattered cheekbone and damage to his eye, as well as extensive amount of as a result of the injuries. So that's the basis, Your Honor, for missing the June 4th. Sounds like it's been quite an ordeal for Mr. Larson, both financially and painfully. So with respect to missing the other test, indicated to me that he either slept in or was working. I think I would agree, Your Honor, that at this point, probation does not appear to be working for Mr. Larson, and certainly we don't want to take up Ms. Stanchek's time and resources. So I don't know that 45 days is necessary, Your Honor, given his financial status and the recovering from the injury. I understand some time is probably appropriate, Your Honor, but if possible, some amount less than 45 days. And any break you could give him, Your Honor, on fines and costs would be appreciated. I'm sure that the medical bills and the fallout from this injury have led to some fairly substantial fines, or costs, I should say, not fines, for Mr. Larson.
Okay. Thank you, Mr. Connolly. So, Mr. Larson, this is your opportunity to tell me anything else you want me to know about why you didn't turn yourself in, and also why you missed the test. So go ahead.
June 4th, I missed the test because it was the day out of the hospital. I was in serious pain and couldn't go anywhere. And then I didn't turn myself in because I had surgery the day I was supposed to turn myself in. And I went through surgery and I rescheduled. I called the jail and tried to reschedule and sent in all the medical paperwork and stuff like that. And yeah, that's about it. And I've been basically at home healing up for about a week and a half now.
Okay. Where were you working prior to that?
It was just a side job with a buddy of mine's dad. I don't know the company name or anything like that.
Okay. All right. Ms. Stanichek, anything you'd like to add?
Yes, Your Honor. Mr. Larson keeps talking about the reasons why he couldn't do the tests due to his injury. We do have verification that he did have an injury. The verification I have, I received 6/6. I'm not sure what date it actually happened on because I can't see the date on the medical paperwork, but I believe he said 6/4. If that's the case, I mean, he missed a drug screen before the injury. He missed many PBTs before the injury. He stopped going to counseling well before the injury. So the injury is not the reason why he's not compliant. He's not compliant because he hasn't been compliant pretty much the whole time he's been on probation. Nothing further.
Thank you, Ms. Okay, thank you, Ms. Stanichek. Okay, so Mr. Larson comes to the court on a probation violation that he's admitted to. The original charge was spray painting a building, causing about $3,500 in damages to the owner, Andrew Fisher. And let's see, the defendant is, well, he was 19 years old when he was sentenced. I'm going to guess he's, 20 now, 21? And, Ms. Stanichek, how much of that restitution has been paid back?
He has paid $1,204 of the restitution. He, let me look at his payment plan. His payment plan was up to date. Yeah, he's not in arrears at all. So he's kept up on his payment plan.
Okay, so he's paying what, $100 a month or something like that?
$150.
$150. Okay. All right. So that's good news anyway. The problem is the defendant was placed on probation, and seems to have basically stopped testing. The concern with drugs was the substance use assessment, where Mr. Larson indicated he smokes 3 or 4 joints a day, at least up until the time he was arrested on this offense. I think it's interesting to note that at 20 or 21 years old, the defendant is still just picking up side jobs. And I'm going to tell you, Mr. Larson, going through life high, I don't know. I guess that's one way to live, but you don't seem to be very productive here. I can't, even though the payment plan was set up, there's no reason why a young person like yourself shouldn't be able to work and get this paid off within a short time. And I think it's probably because you keep smoking dope, and that's probably why you're not testing. So anyhow, that's your choice. But when you go out and cause $3,500 worth of damage to someone else's property, then it becomes my business. And I don't think you've really made an effort here to try to change your behavior. I'm sorry to hear about your accident. So anyhow, I don't think it would make sense to continue with the probation. I think we just have you back here in a short time anyhow. So I am going to terminate probation as unsuccessful. As far as the jail time goes, there's 11 days that have already been served. And that's probably from these previous probation violations. Yeah, there was an additional 5 days for a show cause, unexcused absence from counseling and missing PBTs, failing to do PBTs, 7 days in jail, failing to enroll in mental health counseling or community service. So I guess given that this is only the second offense that the defendant has, in fact, the prior is a civil infraction, MIP, what is a proportionate sentence? Well, I think probably 30 days is sufficient. So that's what I'm going to order. I will give you until Friday at 5 p.m. to turn yourself into the jail. Although I need you to also actually call them and let them know that you've been sentenced to jail, and they will set up the time for you to be taken in. That's because of COVID. I'm going to give you a phone number to call. Have you got a pen handy?
Yes, I do.
Do you have the 533-8627
Yeah.
number? Okay.
Okay, it's 533-8627.
Extension 3230.
627.
Yeah, and
Okay.
extension 3230. Okay.
Okay.
They will let you know when you need to appear, but you need to call them after 1 o'clock this afternoon, okay?
Okay, Your Honor, and may I say one more thing?
Yeah, go ahead.
So I have to heal. Like, if I go to jail with my stitches right now, I'm gonna get a really bad infection.
They have a nurse that that visits the jail to make sure that the prisoners are taken care of. And I guess, can you describe your injuries a little bit better for me?
So I have around, I don't know, 7 to 10 stitches underneath of my right eye. So they could slip a titanium plate underneath of my eye to hold up my eye socket in place. And then I have about 15 stitches all the way down the right side of my inside mouth. That they also slipped another titanium plate through my mouth. And
Okay.
yeah.
All right. I'll tell you what, that does sound painful. And I'm going to give you 30 days to heal up a little before you go to jail.
Okay, thank you, Your Honor.
Okay. So I'm not sure, Ms. Odom, how's that going to work? Should he call the jail on a certain date or what?
I think he should call today. I'm writing on the dispo, defendant to heal before he goes to jail, report after 30 days. And they could probably look at their calendar and set something up 30 days out. Is my
Okay.
guess.
So I'm not sure if you caught all that, but basically I still want you to call the jail after 1 o'clock today. It'll say on the order that they receive that you're to be given 30 days before you turn yourself in, and then they will work with you on how to do that, okay?
Okay, and so say if I heal before them 30 days, then just call the jail and schedule when to turn myself in, or?
Well, hopefully they'll schedule something 30 days out today. That's what I'm hoping for.
Okay.
Yeah, you'll have to talk to them some
Yeah.
more about it, okay? All right.
Thank you.
All right. Well, I know I'm giving you a hard time about the pot, but even in the substance use assessment, your parents are pretty disappointed that you keep using. And, it's sad to see a young person like yourself basically throwing your life away because you can't stop using pot. And I really hope you'll think about that choice and whether it's the best thing for you. There's plenty of people out there that'll tell you it's the best thing since sliced bread. And yet I see someone like you who should have a lot more going on in their life. And it seems like you're just smoking it away. So anyhow, that's my 2 cents, and take it for what it's worth. You're all set for today. Feel free to sign off, okay?
Thank you, Your Honor. Have a good one.
You too. All right, so let's go on to People versus Matthew Ryder. And good morning, Mr. Ryder. And let's see, is Mr. Wims here yet?
I'm representing myself, Your Honor.
You're representing yourself this morning. Okay. So let's see, that is file 202650 SC3. And this is the date set for a plea and sentence on a probation violation. Now, first of all, I want to make sure that that's what you still want to do, is admit to the violation.
It is, Your Honor.
Okay. And I know I just went over this with the last fellow, but I need to make sure you understand that you do have a right to a hearing. You can contest the charge against you, and you have the right to an attorney, including one appointed at court expense if you're unable to afford one. Do you understand all that?
I understand, Your Honor.
And you want to waive those rights, correct?
Correct, Your Honor.
And you also understand the worst that could happen is that you could have your probation revoked by pleading guilty to a violation, and you could be sentenced up to 93 days. And obviously, that's not the recommendation. But like with Mr. Larson, I can't promise what the sentence will be until I've reviewed all the facts and heard from you. Do you understand all that?
I understand, Your Honor.
All right. So then you were placed on probation on July 22nd, 2020 for operating while intoxicated. And as a condition of that probation, you were ordered to not consume or possess alcohol. Is that true?
That is true, Your Honor.
And on May 22nd, you tested positive on a preliminary breath test. It showed a reading of a 0.02 and a 0.021. Is that true as well?
That is true, Your Honor.
Okay, and is that because you did possess and consume alcohol?
That is true, Your Honor.
Okay. All right, then to the violation, how do you plead?
Guilty, Your Honor.
All right, I'll accept your plea and find it's voluntary. So what do you want to tell me about this, Mr. Ryder?
First and foremost, I apologize for you having to see me again. Was hoping not to stand in front of you. The violation occurred the night before. I was at home, put the kids to bed, wife went to sleep, and wife had approximately about half a bottle of wine in the refrigerator. I proceeded to consume it in the basement while watching a movie and immediately had instant regret. And I was well aware that I was most likely going to violate the next day.
Okay. So it was just the temptation of seeing the wine there that made you decide to use it?
It was a stressful week, and I just made the poor choice to relax with a drink of wine. And I usually don't drink wine, but yes, the temptation was there. I had one glass and then decided to consume the rest of the bottle, and basically woke up the next day with my eyes open going, obviously I can't have one glass of wine. That I unfortunately have no stop when I start drinking.
Okay. Have you talked to a counselor about the fact that you did that, or
Yes.
have you followed up with that?
Yes, Your Honor.
Okay.
So that happened Friday night into Saturday morning. On Monday morning, I contacted Catholic Human Services, and I re-admitted myself, and I'm currently doing individual counseling with my first hour-long session coming today at noon.
Okay. Well, that's good. All right. Anything else you want to tell me?
No, sir. Other than I have had no violations since the 22nd, and I hope that you take in consideration my long periods of sobriety other than my violation.
Okay. Thank you. Ms. Stanachuk, anything you'd like to add?
Just that I did receive verification that Mr. Ryder voluntarily went back to Catholic Human Services and did an intake. So he was proactive in taking care of this issue. He did go back to Catholic Human Services back in February when he had consumed alcohol, and they didn't recommend any services for him at that time.
Oh, when was that?
In February, he had a positive PBT
Oh.
for consuming alcohol, so we did a diversion agreement, and he returned to Catholic Human Services, but they didn't recommend any services.
Okay, great. All right then, thank you. So this is sentencing on defendant's probation violation, and the defendant violated by consuming alcohol in this drunk driving case. The defendant has one prior that's been a probation violation that was explained by Ms. Stanichuk. And at that time, there was a diversion agreement increasing the PBTs and reporting the concern to Catholic Human Services. The defendant has completed the terms of the probation, including basic awareness group, victim impact panel, community service work. And so it's a bit, I guess, sad to see you back here again, Mr. Ryder. I know you wouldn't risk going to jail unless you had a serious issue with alcohol. And on the bright side, you seem to fully recognize you got a problem, that you can't even drink one glass without wanting to down the whole bottle. And it's unfortunate that you've got that substance use disorder. But at least this probation has made you aware of the services that are available out there, and you did take proactive steps to re-engage with your counselor and let them know the issue. So,
can I say something, Your Honor? I'm sorry.
Yeah, go ahead. Yeah.
I also want to add in that my wife is in full support. We no longer have any alcohol in the house, and there won't be any. Go ahead. Oh, I'm sorry. Did you not hear that?
Oh, now I can hear you again.
Okay.
I did hear what you said about your wife being fully supportive and no alcohol in the house, and that's important to make it so you don't have those temptations, and it's probably a good idea long-term as well, not just for probation. Hopefully she understands how serious the issue is. And again, you know, just like Mr. Larson, you can do what you want on your own time, but when you get behind the wheel of a car, like you did in this case, and you're intoxicated, then it becomes my business. But anyhow, I think the recommendations are thoughtful. There's a recommendation to extend the probation 3 additional months. I think that makes sense. And enroll in the outpatient substance abuse counseling at Catholic Human Services. Follow all recommendations. That you'll take and pass the twice daily PBTs. And I think that accountability is important. Rather than sentence you to 3 days in jail, however, what I'm going to do is I'm going to sentence you to 3 days of community service work. I reviewed the pre-sentence report. In this case, I see you have no prior record.
Oh, sir.
And I also see that you do coaching, and you're obviously someone who is involved in the community, and I'm sure you won't have a problem coming up with some meaningful community service work to do anyhow. But I'll order that instead of the 3 days in jail. And you know, the point of that is hopefully you'll spend those 3 days helping out in the community, but also thinking about why you're there and how you can tackle this problem better. Otherwise, we'll continue all conditions of probation, and we're all set for today. And Ms. Danachek, are you going to reach out to Mr. Ryder, Dr. Ryder, and talk to him some more about this?
The probation clerks will likely send him a referral for the twice daily PBTs and notify Smart Start, and then I will send him paperwork for the community service work.
Okay. All right. Well, sounds good, and we're all set then for today. Feel free to sign out at this time.
Thank you, Your Honor.
Yep.
Thank you.
Thank you, Ms. Danachek. All right. Rossiter is here, and Mr. Connolly. And we had a preliminary examination scheduled this morning on a Colton Jared Meeker. Is Mr. Meeker present?
Yes, sir, I'm here.
Okay, good morning, Mr. Meeker. So it's my understanding the parties are requesting adjournment for the purposes of holding an in-person hearing. And I think we're going to be going to in-person anyway pretty quick here. So is that correct, Mr. Connolly? You want to hold an in-person preliminary examination?
That's correct, Your Honor.
Okay, Mr. Rossiter, are you agreeable to an adjournment today for that purpose?
Yes, Your Honor. We also would like an in-person preliminary exam. And may I ask Mr. Meeker to take his hat off during the court proceeding, Your Honor?
Okay. Thank you for pointing that out, Mr. Rossiter. I realize it's Zoom, Mr. Meeker, but we do try to uphold some level of decorum in the courtroom. So I appreciate you taking your hat off. I want to make sure that you understand you have a statutory right to have a hearing. Your attorney's advising that you should have that in person. And are you willing to waive your right to a hearing today in order to have that set up so that it is held in person?
Yes, sir.
Okay. All right. So we'll go ahead and pick a new date for that. Ms. Odom, you want to work with Mr. Connolly on that and Mr. Roster?
Sure. How does July 21st sound at 1:30?
Just 1 second. July 21st. Sorry, my computer is, there we go. Maybe it's running a little slow here.
Okay.
I believe that works.
All right.
Yeah, that
Okay.
works.
What date was that?
It's July 21st at
Yeah.
1:30.
At 1:30. Okay. So July 21st at 1:30. And we will be at the Antrim County Courthouse. So is there anything else we need to discuss today, Mr. Connolly or Mr. Roster?
No, Your Honor.
No, Your Honor.
Okay, we're all set then for today. Thank you, Mr. Meeker, and feel free to sign out at this time.
Thank you, sir.
Okay, let's see. We've got another preliminary examination here, People versus Wiltsey. I don't see a defense attorney on my docket.
It's me, Your Honor.
Mr. Cooney.
Oh, it is Mr. Connolly. Okay. And where is Mr. Wiltsey? Is he in jail possibly, or?
He's in the Grand Traverse County Jail, Your Honor. He got sentenced to 11 months in the Grand Traverse County Jail. So.
Okay. I guess before we get started, are you anticipating a hearing this morning?
No, Your Honor, I think Mr. Rossiter agreed to adjourn, stipulate to an adjournment on that matter. There was some discovery I received today that I want to share with my client prior to the hearing, Your Honor. And again, he's in custody, so he's not going anywhere for 10 months plus, so.
All right, have you, well, I suppose we should get the jail here.
Yes, Your Honor.
So, okay, so Ms. Otomo.
I just sent a message. Okay, she's calling.
Did you want to pick a new date while we're waiting?
I was looking at the 21st at 11.
Sure.
July 21st at 11.
This prelim's going to be held, so so just from a timing perspective, I don't know how long Mr. Rossiter anticipates that.
Well, we've got the Meeker prelim scheduled for 1:30. Do you think we can get both prelims in the afternoon, or is Meeker going to take a while?
So if we start this one at 11, what do you think, Ross?
I think if this one were to be, if this one started at 11, I think we would be done. I mean, I'm thinking 45 minutes, an hour tops, if that.
Okay.
Because we may be able to narrow down a couple of points for the purpose of the prelim.
Okay, well, let's go ahead and leave it at 11 o'clock and
Okay.
And Your Honor, can I, Mr. Wiltie, when you get the breakout room?
okay.
Please.
Yeah. All right, good morning, Mr. Wiltsey. This is Judge Cooney, and I'm going to put you in a breakout room with your attorney.
All righty.
So, just sit tight there for a minute. Did you get our civil files for this afternoon?
I do have an email here.
All right, let me get Mr. Wiltsey back.
Sorry, I didn't switch over. I didn't think if he was going to switch over or not.
Okay, Mr. Connolly, were you able to speak with Mr. Wiltsey?
Yes, Your Honor. So Mr. Wilkie, again, I just explained that we had selected an adjournment date for July 21st, and he is amenable to waiving the 21-day rule and having the prelim on the 21st of July, Your Honor.
Okay, so Mr. Wiltsey, Mr. Connolly's explained to you, you've got typically 21 days to have a preliminary examination in this case, unless there's good cause to adjourn it. And apparently you're okay with adjourning the hearing today. Is that correct?
I didn't know that I was waiving a 21-day. I would, if I can get it, I want it as quick as I can have it. I don't want to waive that. That was my bad. I didn't understand that. I do not want to waive. Yeah, I don't want to waive that at all.
Okay. Well, Mr. Connolly, do you want to discuss this some more with Mr. Wiltsey?
Sure.
Because I'm not sure he's completely understands the preliminary examination rules anyhow. So I'm going to put you back in a breakout room here. let me know when
Sure.
he's done and go ahead and close the breakout. It took about a minute and a half to close it.
Okay.
He's all set, Miss Odom.
Okay, thank you. It's gonna be a minute before he comes back. No idea why the breakout room does that.
Does it for every court. I don't know why. But
Oh, yeah, out of nowhere.
All right, we're back on the record in file 213151FY, People versus Thomas Wiltsey. And Mr. Connolly is here for Mr. Wiltsey, Mr. Roster for the People. Mr. Connolly, have you discussed this with your client, and does he still wish to waive his right to a hearing today?
Yes, I did discuss it with him further. I think we have clarification now. He is willing to waive the 21-day time requirement in order to have this hearing at a later date.
Okay, is that true, Mr. Wiltsey?
That's correct. Yes, Your Honor.
Okay. And nobody's forced or threatened you or promised you anything to get you to waive your right to a hearing at your own free will to do so, correct?
No, Your Honor.
No? Okay. All right. So then we'll go ahead and adjourn this out to July 21st. It will be held at
11 a.m.
11 a.m. We are expecting a hearing, and I assume we're going to be back in person at that time. So please be prepared for that. And let's see, is there anything else we need to take up today, Mr. Connolly or Mr. Rossiter?
No, Your Honor. Thank you.
Oh, Your Honor.
Okay, we'll see you back on the 21st then, Mr. Wiltsey, and feel free to sign off at this time or let the jail staff know you're all set, okay?
Okay. Thank you. You all have a wonderful day.
Thank you.
Thank you. All right, thank you, Mr. Roster.